We have a Chad Daybell and Lori Vallow update. Prosecutors scoff at the suggestion that Bryan Kohberger's DNA was planted at the scene. The Gilgo Beach Serial Killer, well, he's a possible suspect in other states. One man's self-defense is another man's murder. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, and make sure you hit that little bell for notifications. And remember, you can listen to us on any of your favorite podcasting apps. Let's go ahead and open the record for July 20th, 2023. Well, some good news for the aunt of Tammy Daybell. The judge has designated her to be the family representative during the sentencing of Lori Vallow. Now, Lori Vallow is obviously scheduled to be sentenced for murdering her two kids, JJ and Tylee, as well as being convicted for conspiring to kill Tammy Daybell, who is Chad Daybell's first wife. So Vicky Hoban, that's the aunt, she will be able to make a victim impact statement on behalf of the family of Tammy Daybell. As you may recall, there were some issues where the prosecution hadn't designated who was a family member and who was entitled to stay in the courtroom or to speak on behalf of the family under the Idaho Victims' Rights Act. So, good thing to know, only 3 years later, we finally have somebody designated, and that's Vicky Hoban. Obviously, it will be interesting to see what she has to say as Lori Vallow gets sentenced on July 31st. And then the appeals shall begin. Now, there was also a hearing canceled today as it related to Lori Vallow's husband, Chad Daybell. As we brought you the news, the attorney for Chad Daybell, John Pryor, wanted to get a copy of the transcript from the trial as well as all of the exhibits. A hearing was scheduled and it was abruptly vacated because the prosecution said, yes, you can have a copy of that. Now, normally, these transcripts are ordered pretty much contemporaneously as they're prepared when you have a co-defendant, particularly if you know you're going to trial. But in this particular case, Mr. Pryor wants the state to share a portion of the expense for the preparation of the transcript. Now, I know in the world of AI, you would think how simple it could be to have a transcript prepared quite easily. Well, it is anything but the case. Let's talk about this. This is the most important person in the courtroom in my estimation, and that's the court reporters. The court reporters have to take down every word and identify who's saying, basically have their own language that they create in this shorthand when they use their little stenographer machines. But what most people don't realize is that usually by the time a transcript is prepared, that court reporter has listened to that hearing or trial about 4 times. Maybe court reporters out there can let me know differently, but obviously they heard it once in court. Then they have their rough draft and they usually listen to it again. And then they listen to it again and then they proofread it. By the time they get done, it's usually been reviewed and listened to at least 4 times to compare the transcript to what was also being recorded. It is a long process. The court reporters usually, even if they're employed by the state, get to keep what it costs to produce the transcripts. It used to be a couple dollars a page. I've seen it as high as $10 per page. And of course, they space it out, really bold letters, a lot of spacing in between lines so that they can get that. But frankly, the court reporters deserve it. But those transcripts can start getting expensive. For a trial that went for several weeks, those transcripts could be $30,000 to $50,000. And I don't think Chad Daybell has that kind of money just laying around. If he did, no wonder why Mr. Pryor wants to get a copy for at least free or maybe at a reduced expense, no doubt. Next on the docket, the prosecutors scoff at the defense theory that somehow Mr. Kohberger's DNA was planted. That's right. Idaho prosecutors responded to a suggestion from the defense that Bryan Kohberger's DNA has been planted at the scene. of last year's quadruple murder, saying it does not support one of their requests for additional discovery. Now, in previous filings, lawyer for Mr. Kohberger asked for more information on the genealogical analysis used to zero in on Bryan Kohberger as a suspect, attempting to cast some doubt on the strength of the investigators' evidence and question whether it pointed irrefutably to just their client. The defense lawyers questioned the investigators' objectivity. Well, the Latah County prosecutors who are prosecuting the case against Mr. Kohberger said in their filings that none of the defense's arguments hold any water whatsoever as reasons to share the additional information that the defense has requested. The state put in their motions, quote, "The state is at a loss as to how the theory supports a claim that the IgG information is material to the preparation of their defense," end quote. Investigative genetic genealogy helped law enforcement eventually link Bryan Kohberger to the crime scene after more common DNA criminal profiling methods called a short tandem repeat analysis, STR, first found no match with the DNA that was left at the scene. Prosecutors said the profile used in their IgG was informed by the same DNA as the STR analysis they performed, and they are already handing over information related to the STR analysis in discovery. Now, if the defendant wishes to explore the theory that his DNA was planted on the K-bar knife sheath, he is free to do so, the prosecutor stated, but the family tree created by the FBI has no relevance to that theory whatsoever, according to the prosecutors. Now, Mr. Kohberger's attorney, as I said, last month said that they should get additional discovery on the genealogical family tree, which help lead law enforcement to their client. The defense said in the June filing that the Kohberger's DNA could have been planted, put on that K-bar sheath by someone other than him, by someone throughout the investigation, perhaps. For instance, which spanned hundreds of members of law enforcement and apparently at least one lab the state refuses to name. The IgG process was like a lineup where the government was already aware of who they wanted to target. Then they said, pointing to 3 additional males' DNA, they say were found in and around the scene after the killings, and noting that precisely how the police came to believe they had identified Bryan Kohberger's suspect car as the kind Kohberger drove is still unknown. The defense continued, stating that they are there to basically guess whether the state focused its investigation on Mr. Kohberger via the bizarrely complex DNA tree experiment or through its faulty identification of the vehicle involved in this case. Now, in their filings Monday, the prosecution said that even if Kohberger's team wants to go down that road and claim that process was rigged, it's completely irrelevant because they're not planning to present the genetic genealogical information at trial. The prosecution said that the IgG analysis was used to point them in the right direction, but it's a separate process from the ultimate STR DNA profile, and they are not planning on using any of it at trial. The prosecution also noted that they have already handed over information related to the STR analysis. These two analyses are distinct, and they say, according to the prosecution, the IgG was used to develop a lead, not to demonstrate substantive evidence of guilt, while the STR analysis is the substantive element of guilt that the state intends to use at trial to prove their accusations against Bryan Kohberger. They include an affidavit from the Idaho State Police Forensic Service Laboratory Manager who notes the STR data and the data used in investigative genetic genealogical cannot be directly compared. Because they don't plan to use the IgG analysis at trial, the prosecution argued it wasn't relevant for the information to disclose, and anyone involved with those analyses wouldn't constitute a prosecution witness, thus making that defense argument inapplicable, they argue. They also argued that the information is neither exculpatory nor material to guilt or punishment, and the family tree built by the FBI merely pointed law enforcement to the defendant, and then law enforcement followed up and developed on substantive evidence of guilt that was used to arrest Mr. Kohberger. So what does that really mean? Obviously, we know that the prosecutors allege that in the early morning hours of November 13th, 2022, Kohberger killed 4 people at the off-campus housing there in Moscow, Idaho. But what does it really mean? We know that the investigators found DNA at the crime scene. They collected that, they analyzed it, they ran it through CODIS systems as well as other databases that the police had access to. The police couldn't come up with anything. So then the investigators started doing the family tree thing, saying, hey, this person is close enough, and they used this private genealogical service that the FBI was involved in. Based upon that, they narrow it down to Kohberger. They get an item from the house in Pennsylvania where Kohberger was. They test that DNA, compare it to what they found at the scene, and they say, there's our match. So what the prosecutor's really saying is, hey, all that family genealogical stuff, it doesn't matter. Sure, it led us in the right direction, but we didn't know if it was really accurate or not until we got the DNA from the house where Bryan Kohberger was staying. And then, of course, they go and get the DNA swab to test it again. And, oh, bam, there you go. You don't have to bring in all that stuff. At least that's what the prosecutor says. Now, the defense can certainly make the argument that their investigation was flawed. That's always a defense that's always an issue that the defense can bring up during a trial, is the investigation or lack thereof. And they can try to raise doubt as to that, but it helps if you actually have the information. Obviously, I don't think it's a road they necessarily want to go down, and you probably may want to try to even avoid that, because people these days hear DNA and they say, oh, we really don't care how you got it. We just know your DNA is there. And unless you can prove that it was planted, the defense has got a tough road to hoe indeed. Now, the defense, they could try to subpoena this information, but needless to say, IGG is going to ask that those subpoenas be quashed if they were even served on them. Interesting issue. It sounds like the prosecution's already turned over a lot of the genealogical information, probably what they needed. And it's very interesting because if there is a flaw in that lead, the defense should be entitled to explore it. But by the time we continue to fight over this, speedy trial continues to tick. Will the defense have enough time? And if the prosecution is turned to turn it over, will the defense have enough time to analyze it? We will have to wait and see. It's always interesting, isn't it? They planted it. Like I said, ladies and gentlemen, it doesn't matter what you think. It doesn't matter what you can believe happened. It only matters what you can prove. And that you need to have somebody come to court and be able to testify as to that. Next, the Gilgo Beach serial killer suspect. That's right. Rex Heuermann could have ties to Atlantic City, according to police. Police are probing whether the Mr. Heuermann, the 59-year-old Long Beach resident, operated in the New Jersey area and has been interviewing jailed sex workers who interacted with him. Apparently, he reached out to them for sex, according to the police, and they are investigating. Apparently, a lot of these sex workers took calls from him, but they did not meet up with Mr. Heuermann. Now, the update from law enforcement comes after it was revealed that the Gilgo Beach killings have similarities to murders in the area by the eastbound strangler, who killed 4 sex workers by strangling them near Atlantic City. Now, in the Long Island case, most of the victims were female sex workers, and several of them were, in fact, strangled. Investigators believe that the architect targeted sex workers he met online. Now, the investigation covers 4 states. Heuermann owns a timeshare in Las Vegas. He has a property in South Carolina, and police are investigating if he could be connected to any unsolved killings in those areas. Now, Heuermann was arrested and charged last week in the killing of 3 of the Gilgo 4, a group of women whose bodies were discovered near Gilgo Beach on Long Island back in 2010. He's pled not guilty to the murders of Melissa Barthelemy, Megan Waterman, and Amber Costello. Heuermann is also the lead suspect in the 2007 disappearance and subsequent murder of the 4th woman, Maureen Brainerd Barnes, though he has not yet been charged in that case. He's also being investigated for the murders of 6 other women whose bodies were found near Gilgo Beach in 2011. Now, a former sex worker previously claimed that she went on a date with the alleged killer, but walked away when she felt uncomfortable. Nicole Brass said she met the alleged murderer at a seafood place in Port Jefferson, Long Island, sometime back in 2014 and 2016. The sex worker said that the conversation quickly turned to true crime documentaries, and Huerman asked if she knew about the 11 unsolved Gilgo Beach killings. Brass said he revealed details, including another death which had not been reported on the news, and that she was weirded out by how thrilled he seemed about the murders. The escort claimed that Huerman indicated that others participated in the murders. Well, anyway, after dinner, Huerman told her to get in my car and invited her back to his Massapequa home. Detectives believe some of the prostitutes were killed in the Manhattan architect's property before being dumped on the beach. The plot thickens. You know how those true crime guys are. Got to be careful about those guys. What are you saying? I don't know. Next on the docket, one man's self-defense is another man's murder. A Georgia man convicted of killing a 19-year-old who accidentally knocked on the wrong door thinking it was his girlfriend's apartment is more than likely going to spend the rest of his life behind bars. Daryl Bynes, he's 36, was sentenced to life plus 15 years on Tuesday for the March 2019 killing of Omarion Banks. That the sentence comes after Bynes was convicted last week of all counts of murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property in the first degree, and possession of a firearm during the commission of a felony. The shooting happened when Banks got dropped off by a Lyft ride and knocked on Bynes' door about 12:30 a.m. Banks' girlfriend has stated that he called her and told her to open the door. But when she opened the door, she didn't see him. She then heard a gunshot, and after that, heard him yell, "I'm sorry, bro. I'm at the wrong house." She said that she heard her neighbor say to her boyfriend, "Nah, bleep, you're not at the wrong house," before firing twice. The girlfriend found Mr. Banks in the grass covered in blood. Mr. Bynes, a father of 5, claimed self-defense, saying he thought that Banks was armed and he was trying to protect his family. Police didn't find any gun on Mr. Banks. A neighbor testified that she heard Mr. Banks apologize. The neighbor stated that she heard, "I was at the wrong door. I'm sorry. I was at the wrong door." Then she heard a "No, you were not at the wrong door," and then pow, pow, pow. You got to be careful, ladies and gentlemen, okay? Normally, now don't rely on me, go to your law in your own jurisdiction. But generally, when you start using a firearm for self-defense, or any weapon for that matter, is you usually have to break the plane of the door. On your porch, not going to cut it. They have to cross the plane. Now, should you shoot them and then drag them inside? No, that would be tampering with evidence. Don't do that. But they have to cross the plane. And you better have a really good explanation as to why you think you had to shoot somebody, just the way it is. That is a question for a jury to decide. Clearly, in this particular case, the jury did not believe Mr. Bynes, and now he's going to go to prison for the rest of his life. It helps if the other person's armed, and obviously, if they're not being threatening to you, you have no reason to use self-defense. So always remember that. And like I said, don't get me wrong, I love firearms. I have an arsenal. But as I tell all my clients, they complicate everything. So you better not use it unless it is clearly the last resort. Finally today, our dumb criminal of the day. How do people come up with this stuff? I don't know. Well, the assistant manager of a South Carolina Burger King has been arrested after allegedly serving customer French fries that had been in the trash can, according to police. Now, Jamie Major was charged this week with tampering with food, a felony for allegedly taking French fries from the trash, adding them to the container where fresh cooked fries are placed, and then dumping just cooked fries on top. Now, the police department responded to the Burger King on a disturbance on July 9th. At the scene, the police found 2 women screaming at restaurant staff, threatening them and using profanity. When the women refused to calm down, the officers basically arrested all of the people and charged them with disorderly conduct. 2 days later, though, the Burger King headquarters called police and told them that Major had been serving fries from the trash can. Now, if convicted, Ms. Major faces up to 20 years in prison, and she might as well get comfortable. She's been unable to make the $20,000 bond and remains in custody. You know, you hear about this stuff where somebody working in the restaurant does something to somebody's food. Just don't do it, ladies and gentlemen. It's a felony. It's just dumb. That's right, Ms. Major, you are dumb. And now you are finding out the consequences of making dumb decisions. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. Hope you enjoyed the show. Join us next time on Crime Talk.